Something else to remember is that if possession and access is being denied by the courts can take some pretty harsh penalties. They can hold the parent who's denying possession in contempt. They can make that parent pay for the attorney's fees required to produce the child and let the other parent see that child. And they can take some other harsh steps that you won't like. I don't recommend that you just outright deny visitation without some substantiated grounds, and that needs, again, backed up by some motion practice, some voluntariness to seek drug counseling, drug testing, alcohol screening, alcohol counseling for that non-custodial parent if that's the issue. If there's a violence issue, that's a little bit different. That needs to be substantiated with sworn affidavit testimony and, again, motion practice. And then, of course, the other thing that the parent needs to do is take a reasonable position, which is that not an outright denial of possession and access, but a request, again, to the court for supervised possession and access because of whatever fears that parent may be able to articulate. But again, those things need to be articulated. If they cannot be agreed upon, they need to be articulated to the court in a proactive manner, not in a reactive manner. Because if you're withholding a child and the other parent files a motion to produce the child, which is called a habeas corpus, in other words, give me my time with my child and pay for my attorney's fees because you're wrongfully withholding it, the courts are going to, the posture of that situation is that you, the parent who may be acting in good faith, have done wrong by the other parent and the child because you're wrongly withholding custody, possession time. So again, being proactive is critical in these scenarios, and making sure that if there's going to be a request for relief to the court and you're the party that feels that compelled to do so first. Don't be reactive, be proactive.